Hello, my name is Justin Sterling. I'm an attorney and the founder of the Sterling Firm. Today, we are discussing how to sue the federal government, the Federal Tort Claims Act. If you have been injured by the wrongful or negligent act of a federal employee, such as an employee of the United States Postal Service, National Parks, or Veterans Administrative Hospitals, then the proper recourse is the Federal Tort Claims Act. The waiver of sovereign immunity. From the beginning of American history, sovereign immunity has protected federal and state governments and their employees from being sued without their consent. The Federal Tort Claims Act serves as the statutory waiver of the government's traditional immunity from tort actions. The elements of a cause of action. There are 6 conditions that must be satisfied in order to impose liability on the United States. 1, the claim must be for money damages. 2, the damage claim must be for injury or loss of property or for personal injury or death. 3, the damage must have been caused by a negligent or wrongful act or omission. 4, the wrongful actor must have been a federal employee. 5, the employee must have been acting within the scope and course of employment. And 6, the circumstances must be such that if the United States were a private person, liability would be imposed under the law of the place where the wrongful act or omission occurred. The procedural requirements. The Federal Tort Claims Act provides the procedural requirements that must be followed to bring a claim against the United States. Title 28 of the United States Code, Section 2675, entitled Disposition by Federal Agency as Prerequisite and Evidence, states, an action shall not be instituted upon a claim against the United States for money damages for injury or loss of property or personal injury or death caused by the negligent or wrongful act or omission of an employee of the government while acting within the scope of his office or employment, unless the claimant shall have first presented the claim to the appropriate federal agency and his claim shall have been finally denied by the agency in writing and sent by certified or registered mail. The failure of an agency to make final disposition of a claim within 6 months after it is filed shall, at the option of the claimant, anytime thereafter, be deemed a final denial of the claim for purposes of this section. And the action under this section shall not be instituted for any sum in excess of the amount of the claim presented to the federal agency, except where the increased amount is based upon newly discovered evidence not reasonably discoverable at the time of presenting the claim to the federal agency, or upon allegation and proof of intervening facts relating to the amount of the claim. The administrative claim prerequisite. Pursuant to the Federal Tort Claims Act, the filing of an administrative claim with the responsible federal agency and the rejection of the claim by that agency is a prerequisite to filing a lawsuit in federal court. The claim must be filed with the proper government agency that employed the wrongdoer. This process is known as exhausting of administrative remedies. The administrative claim must include the exact amount of money damages that the plaintiff is demanding. In addition, the claim must state sufficient facts about the incident to allow the federal agency to investigate the merits of the claim. The claims are barred unless submitted in writing to the responsible federal agency within 2 years from the date of the accident. Moreover, if the lawsuit is filed in the federal court before the notice of claims requirement is satisfied, the case will be dismissed. The standard Form 9-5 prescribed by the Department of Justice entitled Claim for Damages, Injury, or Death may be used for the filing of a claim against most federal agencies. The sum certain requirement. The claim must be for money damages in a sum certain. Pursuant to Title 28 of the United States Code, Section 2675B, the amount of damages awarded in a lawsuit is limited to the amount stated in the administrative claim. An exception is when an increased amount is based upon newly discovered evidence not reasonably discoverable at the time of presenting the claim. The statute of limitations to file the lawsuit. A federal complaint must be filed within 6 months after the date of the government's notice of final denial of the claim. The failure of the responsible federal agency to make a final disposition of the claim within 6 months can be deemed a final denial of the claim, and a lawsuit can then be filed in federal court. As a practical note, the 6-month statute can run out even though 2 years from the date of the incident has not yet elapsed. The lawsuit must be filed in the United States District Court where the plaintiff resides or where the incident occurred. The employment relationship. The wrongdoer must be an employee of the federal government. If there is no employer-employee relationship, the plaintiff cannot bring a lawsuit under the Federal Tort Claims Act. An independent contractor hired by the government does not amount to an employer-employee relationship. An employment relationship is required to have government liability. The United States as the defendant. The United States of America is the proper defendant to be named in the complaint. If the plaintiff only names the federal employee individually and files the complaint in state court, the lawsuit will most likely be removed to federal court even though the lawsuit failed to name the federal government. This rule only applies to an employee who committed the negligent act within the course and scope of employment. If the complaint alleges that the act was committed outside the scope of employment, the individual can be sued personally in state court. The limitation of claims. The Federal Tort Claims Act specifically excludes common law claims for which a private person would be liable, including claims for assault, battery, false imprisonment, false arrest, malicious prosecution, abuse of process, libel, slander, misrepresentation, deceit, and interference with contractual rights. If the claimant is injured in any of these particular situations, the claimant will not be able to file suit against the government under the Federal Tort Claims Act. In addition, because the jurisdictional grant is for torts arising from a negligent or wrongful act or omission, the Federal Tort Claims Act does not support claims for strict or absolute liability. The Federal Tort Claims Act also excludes several classes of plaintiffs, including 1. Active duty service members and their families injured incident to service, and 2. Federal employees injured while performing their duties. In such situations, the Federal Employees Compensation Act, FECA, is the exclusive remedy against the United States. The limitations of remedies. In addition to being limited to the amount stated in the administrative claim, a damages award pursuant to the Federal Tort Claims Act may not include prejudgment interest or punitive damages. Moreover, only money damages are available under the Federal Tort Claims Act. Equitable remedies are not recognized. Attorney fees. Pursuant to Title 28 of the United States Code, Section 2678, the plaintiff's attorney may only charge 20% of any settlement of claim made by a federal administrative agency prior to filing a lawsuit, and only 25% of any judgment resulting from litigation. In fact, an attorney who charges more is subject to a penalty or even jail. Also, no additional attorney fees may be charged on appeal.